Well, but another point, I'd like to talk about judiciary activism with free liberty to motivate decisions principle, to show how I think Brazilian judges were far away with this principle. And I talked in this week in a congress in São Paulo, in USP, just for federal judges, talking this point. I think we were going far enough. I'd like to talk a personal experience. When judges start the job in Brazil, they worked part-time in a school, court, and part-time with the courthouse. And I was a tutor of this group 2 years ago, and once one of the new judges told me very proudly, well, today I revealed a decision of a senior judge. And I asked him why that decision was wrong, and the answer was, no, but I think differently. I think with 17,000 judges thinking differently, we don't have a system, we have a chaos. And I think these two situations, but first of all, I know that academically speaking, it's difficult to talk just about personal experience, and then I show some information that we can prove. We can do a Google and to see it. There's two opinions that I'd like to show. One, first one, it's about former Justice José Delgado from the STJ, that second level court. He talked once about the imprevisibility of judicial decisions. He was talking in a tax law congress, and in a brief research he had done, he identified 33 points with the STJ parts or sections of the court was deciding differently in the same time. Remember, the constitutional obligation of this court is to unify the federal interpretation, the interpretation of federal law. And the court was or are deciding in one point in ways absolutely different. And here identified in 33 situations like that. And the last one is about former Justice Humberto Gomes de Barros. He talked it in a judgment, then it's part of a vote known as banana boat vote. I'd like to summarize this situation. On beaches, there is a game when a pilot of a boat drops everybody off a float. He told that the court was working like the pilot of the banana boat game, dropping the jurisdictional off. Well, I think these two situations justify why Parliament decided to approve this new law, this new civil procedure law, importing binding precedents from the common law. I'd like to talk very faster with 3 articles. One, this when Parliament, it's mandatory now, courts must standardize their decisions and ensure that they remain stable, integrated, and coherent. If I show it before, probably you can ask me, but judges in Brazil don't work and then don't maintain your decisions stable, integrated, and coherent? The answer was no. I answered before. The next article is a bit huge. I just like to show that in this article, Parliament organized a system to buy precedents. There's a constitutional problem with this article. If we have time, I can talk a bit more about it. But anyway, for me, the more important is identify the characteristics of elements of the doctrine of precedents. And then I went to London to try to understand better, and I identified four elements or four characteristics. Three of them, it's very easy to show in our new law. It's applying the precedents, it's distinguishing about two different cases, and the overruling the precedent. The first, more easy, applying precedent. When judge identify that this situation in judgment, it's like the same of another situation decided before for another court, another high court, and then the judges just need to demonstrate that the case under judgment conforms to those grounds. The second, distinguishing a precedent. In that case, the law is forbidding to judge to cease to follow a statement of summa, jurisprudence, or precedent invoked by the party without showing the existence of a distinction in the case of judgment. It's a little more technical, but it's sometimes important to identify that one point is different for another one because there's a personal situation in that case, etc. The third one is the overruling a precedent when the situation was moved, like there's another statement or another social development, and then courts decided don't apply that precedent anymore. Otherwise, will be a very straightforward or conservative structure. Well, but I'd like to talk about one problem. Actually, it was about one case that I tried to understand more when courts decide against statute in binding precedents. To remember, our federal constitution determines principle of legality. No one shall be obliged to do or refrain from doing something except by virtue of law. Then the law is the most important point. But in one decision, STJ changed its jurisprudence about limitation period to start a tax enforcement and didn't apply the national tax code as usual and started applying one article of the old CPC, but the court decided applying just half of one article, not the whole article. You can imagine a court deciding in one way for 21 years. In one moment, the court decided, no, I'm going to decide in another way, but in that case, to actually, if the court had decided for the tax code or the procedure code in a whole article, taxpayer will have been win this case. To government won this case, like this one, court needed to change for one code for another code, but applying just half of an article. There's no rules about interpretation of law that authorize or with authorization to court applying just half of an article. And of course, decided that case was binding precedent. And then I'd like to show the fourth characteristic of doctrine of precedents, a decision per incuriam, or in Portuguese, uma decisão descuidada. What is a decisão descuidada or a per incuriam decision? when a court does not mention a previous precedent or statute used as the legal basis of one of these parties. What is the consequence?